recognizes the gentlewoman from California's Ms. Walters for 5 minutes.
Oh, sorry.
Hi, Director Comey. Despite the absence of an intent mens rea standard in 18 U.S.C. Section 793F, you have said that there has never been a prosecution without evidence of intent. Thus, the standard has been read into the statute despite the specific language enacted. What exactly are the legal precedents that justify reading intent into the statute?
Well, my understanding of 793F is governed by a couple things, three things really. One, the legislative history from 1917, which I've read, and the one case that was prosecuted in the case. And those two things combined tell me that when Congress enacted 793F, they were very worried about the gross negligence language and actually put in legislative history, we understand it to be something very close to willfulness. Then the next 100 years of treatment of that actually tell me that the Department of Justice for a century has had that same reservation because they've only used it once. And that was in a case involving an FBI agent who was in an espionage context. So those things together inform my judgment of it.
Considering the importance of protecting classified information for national security purposes, a lot of people disagree that an intent standard should be read into that statute. What specific language would you recommend we enact to ensure gross negligence is the actual standard for the statute, not intent?
I don't think that's something the Bureau ought to give advice on. It's a good question as to what the standard should be. I could imagine federal employees being very concerned about how you draw the line for criminal liability, but I don't think that's something we ought to advise on, the legislation.
Okay. Should we enact a mens rea standard for extreme carelessness for the statute?
Same answer, I think, is appropriate.
Should we enact a civil fine?
A civil fine for mishandling classified information? I don't know, actually, because it's already subject to discipline, which is suspension or loss of clearance or loss of job, which is a big monetary impact to the people disciplined. So I don't know is whether it's necessary.
Okay, I want to change subjects for my next question. As you know, the number of criminal background checks for non-criminal purposes, such as for employment decisions, continues to increase annually. I don't expect that you have this information on hand. However, would you be willing to provide the committee and my staff with the number of criminal history record checks for fingerprint-based background checks that the FBI has conducted over each of the past 5 years? And what are your thoughts regarding whether the FBI has the capacity to process the increasing number of background check requests?
I'm sure we can get you that number because I'm sure we track it, so I'll make sure my staff follows up with you. I do believe we have the resources. Where we've been strained is on the background checks for firearms purchases. The other background check processes we run, my overall sense is we have enough troops to do that. We charge a fee for those, and I think we're able to generate the resources we need.
Okay. Thank you. I yield back my time.
Okay.
Could the gentlelady yield to me?
Sure. I'd be happy to yield to you.
Thank you. Thank you. Director, some time ago you appeared before this committee and you told us that you had exhausted all of the capability to unlock the San Bernardino iPhone, the 5C. Did that turn out to be true?
Still true.
That you had exhausted all of your capability?
At the FBI had, yes.
So shouldn't we be concerned from a cyber standpoint that you couldn't unlock a phone that, in fact, an Israeli company came forward and unlocked for you, and basically a Cambridge professor or student for $90 is shown also to be able to unlock and mirror or duplicate the memory? And this is purely a question of you apparently do not have the resources to do that which others can do. Isn't that correct?
I'm sure that's true in a whole bunch of respects, but first I got to correct you. I'm not confirming. You said an Israeli company. I'm not.
Well, okay. A contractor for you reported to be for $1 million unlocked the phone. So I would ask you to confirm the phone got unlocked, right?
Yes, it did.
Okay. So the technology could be created outside of ordering a company to essentially re-engineer their software for you, correct?
Yeah, in this particular case, yes.
Okay, and so you lack that capability. How can this committee know that you're in the process of developing that sort of technology, the equivalent of the Cambridge $90 technology?
How can the committee know?
Yeah. I mean, in other words, where are the assurances that you're going to get robust enough? We have an encryption working group that was formed between multiple committees. to no small extent because of your action of going to a magistrate and getting an order because you lack that capability, and we're trying a new technique of ordering a company to go invent for you. The question is, how do we know that won't happen again, that you will go to the court, ask for something when in fact the technology exists or could exist to do it in some other way, a technology that you should have at your disposal, or at least some federal agency should, like the NSA?
Well, first of all, it could well happen again, which is why I think it's great that people are talking about what we might do about this problem. It's an interesting question as to whether we ought to invest in us having the ability to hack into people's devices. Whether that's the best solution doesn't strike me as the best solution, but we are, and I've asked for more money in the 17 budget, trying to invest in building those capabilities so when we really need to be able to get into a device, we can. It's not scalable, and I'm not sure it would be thrilling to companies like Apple to know we're investing money to try and figure out how to hack into their stuff.
Well, isn't it, and I'll be brief, isn't it true that we have clandestine organizations who have the mandate to do just that? To look around the world and to be able to find information that people don't know you can find, keep it secret, get it out there. And my question to you is, shouldn't we, instead of giving you the money, simply continue to leverage other agencies who already have that mandate and then ask you to ask them to be your conduit for that when you have an appropriate need?
And that's a reasonable question. It may be part of the solution. Real challenges in using those kinds of techniques in the bulk of our work because it becomes public and exposed. But that has to be an important part of the conversation.
Thank you. Yield back.
The Chair recognizes the gentleman from Arizona, Mr. Franks, for 5 minutes.
Thank you, Mr. Chairman, and thank you for being here, Director Comey. Director Comey, the last thing I want to do is to lecture you on anything related to the law. Because I think you've given your whole life to that effort. And I guess in the face of so many things already having been said here and asked, that all I can do is to try to sort of associate this in a reference of why there is a rule of law. You know, we had that little unpleasantness in the late 1770s with England over this rule of law, because we realized there's really only two main ways to govern, and that is by the rule of men or the rule of law. And sometimes it's important for all of us just to kind of reconnect what this whole enterprise of America is all about. And I, again, don't seek to lecture you in that regard. And I know, and you have to forgive me for being a Republican partisan here because I am very biased in this case. But I know that when you interviewed Mrs. Clinton, you were up against someone that really should have an earned doctorate of duplicity and deception hanging on her wall. I don't know that you probably could have interviewed a more gifted prevaricator. So I know you were up against the best. But having said that, when I read the law here that I know so many have already referenced, I think maybe that's the best way for me to do that. 18 U.S.C. 1924 provides that any federal official who, quote, becomes possessed of documents or materials containing classified information of the United States and knowingly removes such documents or materials without authority and with the intent to retain such documents or materials at an unauthorized location shall be fined under this title or imprisoned for not more than 1 year or both. Now, I didn't miss one word there. It does not require, that section does not require an intent to profit. It doesn't require harm to the United States or otherwise to act in any manner disloyal to the United States. It only requires intent to retain classified documents at an unauthorized location. And I believe, sir, in all sincerity to you, person to person, I believe that some of your comments reflected that that's what occurred. Over the last several months, I believe that's the case. And So I have to, it's my job to ask you again, why the simple clarity of that law was not applied in this case, because the implications here are so profound for your children and mine, for this country. They are so profound. And again, I don't envy your job, but I want to give you the remainder of the time to help me understand why a law like this that any law school graduate, if we can't apply this one in this case, how in God's name can we apply it in any case in the world? Why is it even written? So I'm going to stop there and ask your forbearance and just go for it.
Sure. No, it's a reasonable question. That is the 18 U.S.C. 1924 is the misdemeanor mishandling statute. That is the basis on which most people have been prosecuted for mishandling classified information have been prosecuted. It is not a strict liability statute. I was one of the people when I was in the private sector who argued against strict liability criminal statutes. It requires, in the view of the Department of Justice and over long practice, proof of some criminal intent, not specific intent to harm the United States, but a general awareness that you're doing something that's unlawful. So you have to prove criminal intent. So there's two problems in this case. One is developing the evidence to prove beyond a reasonable doubt that Secretary Clinton acted with that criminal intent. And second, even if you could do that, which you can't, looking at the history of other cases, what would be the right thing to do here? Has anybody ever been prosecuted on anything near these facts? And again, I keep telling the folks at home, when people tell you lots of people have been prosecuted for this, please demand the details of those cases, because I've been through them all. So that combination of what the statute requires and the history of prosecutions told me, and again, people can take a different view, and it's reasonable to disagree, that no reasonable prosecutor would bring that case. That, in a nutshell, is what it is.
You said it was a reasonable question, it was a reasonable answer, but I can't find that in the statute. Thank you, sir.
The chair recognizes the gentleman from Louisiana, Mr. Richmond, for 5 minutes.
Thank you, Mr. Chairman. Director Comey, and I'm going down a completely different path. Our law enforcement in this country have a consistent enemy in a group called sovereign citizens. And what I have seen in my district, we lost 2 officers in St. John Parish about 4 years ago. And we just lost another 3 officers in Baton Rouge with another couple injured. In the case in St. John Parish, we actually had the perpetrators on the radar in North Louisiana. And at some point, they moved to South Louisiana in my district, and we lost contact. So when St. John Parish deputies went to their trailer park, they had no idea what they were walking into, and they walked into an ambush with AR-15s and AK-47s, and the unimaginable happened. So through NKIC and other things, are you all focused on making sure, and I think there are about 100,000 of them, but are you all focused on making sure that our law enforcement has the best information when dealing with whether it's sovereign citizen or terrorist cells or other bad actors, that information gets to the locals so they're not surprised and ambushed?
Well, we sure are, and I don't know the circumstances of that case, but I will find out the circumstances. In 2 respects, we want, obviously, people to know when someone's wanted, but more than that, we have a known or suspected terrorist file that should have information in that about people we are worried about, so that if an officer is making a stop or going up to execute a search warrant and they run that address of that person, they'll get a hit on what we call the KST file. So that's our objective. And if there are ways to make it better, we want to.
Now let's switch lanes a little bit, because this is one of, I think, an issue when we start talking about criminal justice reform and we start talking about the FBI. In my community, in communities of color, and with elected officials, there seems to be 2 standards, one for low-level elected officials and then one for other people. So I guess the facts I will give you in some of our cases, and you tell me if it sounds inconsistent with your knowledge of the law and your protocol, but nonprofit organizations where elected officials have either been on boards or had some affiliation with, when those funds are used in a manner that benefits them personally, they have been prosecuted. And I mean for amounts that range from anywhere from $2,000 upwards to $100,000. Your interpretation of the law that if a nonprofit funds are used to benefit a person and not the organization, that is a theft of funds, because I believe that those are a lot of the charges that I have seen in my community. Would you agree with that?
Sure, it could be, and I know from personal experience, having done these cases, that's at the center of a case involving a corrupt official.
Now, let's take elected official out and just take any foundation director or board director or executive director who would use the funds of a nonprofit to pay personal debts or bills or just takes money. You would agree that that would constitute a violation of the law, criminal statute?
Potentially. On the federal side, potentially of wire fraud, mail fraud, or a tax charge, potentially.
The other thing that I would say is that in our community, we feel that it's selective prosecution, that if you're rich, you have another standard, that if you're an African American, you have another standard. And there are a number of cases that I will give you offline, but it appears that, in my concern, is the authority of your agents to decide that a person is bad and then take them through holy hell to try to get to the ultimate conclusion that the agent made, and they don't let the facts get in their way. And at the end of the day, you have business people who spend hundreds of thousands of dollars to protect their reputation and to fight a charge that they ultimately win, but now they are broke, they're defeated, because when it comes out, it says the United States of America versus you. So I would just ask you to create a mindset within the department that they understand the consequences of leaks to the press, charges, and what happens if, when those charges are really not substantiated, you still break a person. And I think that you all have a responsibility to be very careful with the awesome power that you all are given. And with that, Mr. Chairman, I would yield back.
Chair, thanks, gentlemen. The director is welcome to respond. If he
I very much agree with what you said, Congressman, at the end of that. The power to investigate is the power to ruin. Obviously, charging people can also be ruinous, so it's one we have to be extraordinarily prudent in exercising, fair, open-minded, and careful. So I very much agree with that.
Chair recognizes the gentleman from Michigan, Mr. Trott, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Director, for being here, and thank you for your service to our country. When you made your statement at the press conference on July 5th, you said, "I have not coordinated or reviewed this statement in any way with the Department of Justice or any part of government. They do not know what I'm about to say." I have no reason to question your integrity, but is there any chance that someone working in your office or as part of this investigation knew what you're going to decide and recommend, and maybe told one of the Attorney General's staff what was about to happen on July 5th?
Yeah, look, anything's possible. I think I'd be willing to bet my life that didn't happen, just because I know my folks.
So here's why I ask. The facts give me pause. Investigation started in July of 15. Many of us in Congress, including myself, suggested that the Attorney General should recuse herself because of her friendship with the Clintons and because of her desire to continue on as Attorney General in the Clinton administration. Then she had the fortuitous meeting on the airplane with former President Clinton on June 30th. Then on July 2nd, give or take, she came out and said, I've created an appearance of impropriety, and so I'm going to just follow whatever the FBI director's recommendation is. And then 3 days later, you had your press conference. And in your press conference, you said, in our system of justice, the prosecutors make the decisions about what charges are appropriate based on the evidence. That's not what happened in this case. Ultimately, you made the decision. Isn't that what happened?
Well, look, I made public my recommendation. The decision to decline the case was made at the Justice Department.
But before you had that press conference, you knew, based on the Attorney General's public comments, that she was going to follow whatever you recommended. So ultimately, you made the decision in this case as to whether or not charges should be filed against Secretary Clinton. Isn't that the reality of what happened?
I think that's a fair characterization. The only thing I'd add to that is I think she said, I don't remember exactly, that she would defer to the FBI and the career prosecutors at the Department of Justice. But look, I knew that once I made public the FBI's view that this wasn't a prosecutable case, that there was virtually zero chance that the Department of Justice was going to go in a different direction. But part of my decision was based on my prediction that there was no way the Department of Justice would prosecute on these facts in any event. So I think your characterization is fair, but I just wanted to add that color to it.
But you can see how some of us would look at the dates and the facts leading up to your press conference and think, okay, for a year we've been suggesting she's not the appropriate person to make the ultimate decision as to whether charges should be filed. She won't recuse herself, and then 3 days before you come out with your recommendation, which she's already said she's going to follow, she basically decides to recuse herself. Those facts give me pause.
Yeah, I get why folks would ask about that, but I actually think there are two dates that matter. I think,
Right.
but what generated that was the controversy around her meeting with President Clinton, not the interview with Secretary Clinton.
That's a whole other discussion. So let's talk about Cheryl Mills. So you've said earlier today that it really wasn't up to you to weigh in on whether there's a conflict for Ms. Mills to act as Secretary Clinton's lawyer in the interview. But again, you're kind of taking your attorney hat on and off whenever it's convenient. You decided that at the beginning of that interview it wasn't appropriate for you to weigh in as a lawyer suggesting there was a conflict, but then again, your recommendation is ultimately, as a lawyer, what's being done in this case. You see a little bit of inconsistency there, or no?
No, I see the point about look, I would rather not have an attorney hat on at any time. I put it on because I thought that was what was necessary at the conclusion of this investigation. But I stand by that. The agents of the FBI, it's not to them to try and kick out someone's lawyer.
What would have happened if you had said, Ms. Mills, because of the history here, you can't be in this interview?
I don't know. I don't know.
Could you have said that to her?
I guess you could. It would be well outside our normal role.
So a number of times today you've said there really is no double standard. And so now I'm just asking you as a citizen, and not even in your capacity as Director of FBI, can you sort of see why a lot of Americans are bothered by a perceived double standard? Because if any of the gentlemen sitting behind you this morning, I assume were with the department, had done some of the things Ms. Clinton did and told some of the lies that she told, you said in your statement that this is not to suggest under similar circumstances there wouldn't be consequences. In fact, they'd be subjected to administrative sanctions. And now we have an election going on where she's seeking a pretty big promotion. So maybe your point is she wouldn't be charged under similar facts, but can you sort of see why so many people are bothered by the facts in this case, given that really nothing happened to her and now she's running for President of the United States? I mean, can you see the optics on that are troubling?
Oh, I totally get that. That's one of the reasons I'm trying to answer as many questions as I can, because I get that question. But again, folks need to realize, in the FBI, if you did this, you'd be in huge trouble. I'm certain of that. You'd be disciplined in some serious way. You might be fired. I'm also certain you would not be prosecuted criminally on these facts.
And you've said that, and I appreciate that. Let me just ask one quick question because I'm out of time. But Mr. Bishop started to talk about this, and his district is affected as well in Michigan. But my district in southeast Michigan has the third largest settlement of Syrian refugees of any city in the country, behind San Diego and Chicago. That's Troy, Michigan. And you said last fall in front of a Homeland Security Committee hearing that you really didn't have the data to properly vet the Syrian refugees that are trying to come in. And you said that again this morning. But, last weekend I'm at a grocery store and a Starbucks, and two different constituents walked up to me and said, can't you stop the President's resettlement of Syrian refugees in Detroit, Michigan? We're all afraid. And they're based on largely your comment that we don't have the database to really vet these folks. Anything I can tell the folks back in Michigan that we're doing, other than all I say now is we just have to wait for a new president, because this president has increased the number of refugees by 60% and 30% year over year the last 2 years. We just have to wait for a new president. I'd like to be able to say the FBI is doing something different than they were doing last year when you made those comments.
Well, as I said earlier, they can know that we are, if there is a whiff about this person, somewhere in the U.S. government's vast holdings, we will find it. And the second thing they can know is if we get a whiff about somebody once they're in, we're going to cover that in a pretty tight way. What I can't promise people is that if I can't query what's not in our holdings. That's the only reservation I offer to people.
Thank you, sir. I yield back.
Well, Director Comey, during questioning earlier, there was a dispute that arose over the contents of one or more of the immunity letters that were issued, particularly with regard to the issue of whether or not it contained immunity for destroying documents, emails. The individual who was questioning you about that was former Chairman Issa of the Oversight and Government Reform Committee, and I want him to be able to clarify, because we have contacted the Department of Justice and asked them to read the immunity letters to us. So the gentleman is recognized briefly.
Thank you, Mr. Chairman. I'll try to be very brief. Under the immunity agreement with one or more individuals, we'll use Cheryl Mills as clearly one of the individuals. She negotiated a very, very good deal from what we can discover. She did not just receive immunity related to the production of the drive, the computer, and the contents, but in fact received immunity under 793, 18 U.S.C. 793E and F, 1924, USC 1920, 18 U.S.C. 1924, and the so-called David Petraeus portion, 18 U.S.C. 2071. And I'll focus on 2071. Her immunity is against any and all taking, destruction, or even obstruction, the way we read it, of documents classified or unclassified. Now, the only question I have for you is, and I know you're going to put this to justice, and we may have to ask them separately, for the purposes of what you needed as an investigator, because you were the person that wanted access to the computer, is that deal make any sense to, in return for things which she could have objected to as an attorney and held back, but which had no known proffer of leading to some criminal indictment of somebody else, she received complete immunity, as we read it, from obstruction or destruction of documents classified and unclassified, and that's based on a re-review of the immunity agreement.
Yeah, I think this is you're right. This is a question best addressed to Justice, but I think you're misunderstanding it. As I understand it, this was a promise in writing from the Department of Justice. If you give us the laptops, we will not use anything on the laptops directly against you in a prosecution for that list of offenses. It's not immunity for those offenses if there's some other evidence. Now, that said, I'm not exactly sure why her lawyer asked for it, because by that point in the investigation, we didn't have a case on her to begin with.
Well, I understand that, but based on the Reddit discovery and others, they asked me to do it, and you said so yourself, it was probably Cheryl Mill, they. You have an immune witness who has to tell you who they were. If they were told me to delete, and that's Cheryl Mills, then in fact you have evidence from an immune witness of a crime perpetrated by Cheryl Mills, the ordering of the destruction of any document classified or unclassified, which clearly she seems to have done.
But she wouldn't be protected from that. If we developed evidence that she had obstructed justice in some fashion, all she's protected from is we can't use as evidence something that's on the laptop she gave us.
So with the
prosecutor.
Right. So the information put into the record today, which included these Reddit discoveries, show that there is a they who asked to have the destruction of information under 18 U.S.C. 2071. If she doesn't have immunity for that order, she could, and by definition should be charged, because ordering somebody else to destroy something as an attorney well after there were subpoenas in place that were very specific, that's clearly a willful act, isn't it?
Mr. Chairman, would you yield?
Of course.
Your line of questioning, first let me show my cards. I believe that Cheryl Mills has an impeccable character, as my line of questioning suggested that Director Comey and his staff have impeccable character. But my good friend, there's immunity given. I don't think this applies to Ms. Mills, and I looked at the sections that you're speaking of. If you take local criminal and state actions given to the worst of characters for a variety of reasons, that was not the reason given to Ms. Mills. I am assured that it is a lawyer that was trying to be the most effective counsel to Ms. Mills as possible.
Well, reclaiming my time, the gentlelady's point may be true. I'm only speaking to the director based on things were done that should not have been done. we now have evidence in front of this committee in the record of people destroying records of activities as late as a few days ago. So the fact that there still should be an open question, first of all, is could she be prosecuted? And if, in fact, they have told me to destroy this, under the exact same statute that included David Petraeus's, who was no longer on active duty, 18 U.S.C. 2071, there's at least a case to be made. Now, the problem we have is the lawyer negotiated a set of terms which hopefully doesn't mean that she gets a free pass, even if she willfully ordered the destruction of documents, which it does appear she did. And look, my job is not to be judge, jury, or hangman. My job is to look at what's been presented to us, ask the highest law enforcement officer in the land to, in fact, look into it, because it does appear as though it is there.
A brief yield, my good friend.
Of course.
Certainly, we have an oversight responsibility of the director. I think he's been very forthright. But none of the actions of destruction can be attributed. I don't think we have anything in evidence to suggest that Ms. Mills contributed to the dictating or directing.
Well, the gentlelady may not have been.
Destruction.
The gentlelady may not have been here.
So we can't speculate here.
The gentlelady may not have been here at the time, but the director himself, when asked who they would have been in that order to destroy, at least said it probably was or likely could have been Cheryl Mills. We're not saying it is. What we're saying is you have an immune witness.
The gentleman will suspend.
Of course.
The purpose of this was to set the record straight as to what the content of the document was. That has been accomplished, and the debate will continue on, but it will continue on outside of this hearing room.
And I would only
cannot speculate.
And I would only ask that the director be able to review those documents at justice and follow up with the committee. Would be very helpful to all of us. I thank the chairman.
The director has answered in the affirmative that he will do that.
Yes, we'll follow up.
First of all, I want to thank Director Comey. We didn't make 4 hours and 40 minutes, but we did almost make 4 hours, and I know you have been generous with your time. However, I will also say that I think a lot of the questions here indicate a great deal of concern about the manner in which this investigation was conducted, how the conclusions were drawn, and the close proximity to that, and the meeting of the Attorney General with former President Clinton on a tarmac. At the same time, she then said, well, I'm going to recuse myself, and then shortly after that, you took over and announced your conclusions in this case, which are hotly disputed, as you can tell. The committee and the Oversight and Government Reform Committee have referred to the United States Attorney for the Eastern District of for the District of Columbia, referral based upon her testimony before the Select Committee on Benghazi, suggesting that your statement at your press conference and your testimony before the Oversight and Government Reform Committee very clearly contradicted a number of statements she made under oath before that committee. And I want to stress to you how important I think it is that we made that referral for the purpose of making sure that no one is above the law. And in many cases regarding investigations, it is not just the underlying actions that are important, but they are the efforts of people to cover those up through perjury, through obstruction of justice, through destruction of documents. And so I would ask that this matter be taken very, very seriously as you pursue whatever actions the Department chooses to take, making sure that no one is above the law.
Thank you, sir.
With that, concludes today's hearing, and I thank our distinguished witnesses for attending. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record, and the hearing is adjourned.